Did you know that California has one of the strictest real estate disclosures laws in the entire country? And if you do not know what those disclosures are and what do they mean or how to fill them out correctly, you can get yourself into trouble without even realizing it. Hi, this is Rima Rafe with the Rafe Group with the XP Realty here in the Santa Clarita Valley, Los Angeles area. And let me start with something most California homeowners have no idea about. When you sell a home in California, you're legally required to tell the buyer everything that can affect the value or desirability of your property. Not just some things, not the things you feel comfortable sharing, not what you think matters, but really everything. So today, I'm breaking down something that almost nobody explains clearly. Not your agents, not some attorneys, not lenders, not even the internet. And that is what California sellers actually have to disclose when they sell a home. Why these documents matter, what's included, and how to fill them out, and how to protect yourself legally. And here's a big point I wanna cover. Most sellers don't understand disclosures. Most sellers are terrified of filling them out. And many sellers make mistakes not because they are hiding something, but because they did not understand what the questions were really asking. So, if you're planning to sell your house in Los Angeles County, Santa Clarita Valley, or in California in general, this video is going to save you stress, confusion, and possibly thousands of dollars in legal problems down the road. I have guided countless sellers through California's disclosure process, and what I've learned over the years is this. When sellers understand what they're filling out and why, the entire transactions becomes easier, clearer, and safer. So let's dive into the California disclosure world together and break everything down in plain English. Let's start with the big one, TDS, which means Transfer Disclosure Statement. This is the California seller's main disclosure documents, and if you've never seen it before, it can look intimidating, but the TDS is really just a giant checklist. It asks you to tell the buyer about the physical condition of the property as you know it. You don't need to be a contractor, and you do not need to be an engineer. You do not need to be an expert. The law simply requires you to disclose what you are aware of. The TDS, which refers to the Transfer Disclosure Statements, covers things like: is there a leak on the property? Has there ever been a water intrusion? If there's any appliances not working? And does the roof have any issues? Are there any cracks on the walls? Has anything been repaired recently? Or are there any defects or malfunctions? Do you know any of the hazard stuff that might be going on your property? If you know about it, you disclose it. If you do not know about it, you don't guess. You simply state that you are not aware. What really scares sellers is the idea that disclosures hurts their sale. But the truth is the opposite. Buyers trust homes that are disclosed clearly, way more than homes with vague or missing details. Disclosures help you, definitely does not hurt you. Now let's move on to the second big disclosure document, and it's called the SPQ, which is the Seller Property Questionnaire. That SPQ goes over even deeper. This one about things you may have experienced while living in your home. Noise issues, neighbor dispute, past insurance claims, or anything unusual that happened in or around the property. The SPQ is more personal because it asks about things you would know as a homeowner. And here's the most important rule. If you remember something, even if it's minor, it's better to disclose it. California's rule is simple. When in doubt, disclose. Buyers don't sue because a seller told the truth. Buyers sue when they feel the seller hid something. Now let's talk about something very California specific, and that is Mello Roos. If you live in a newer community, especially in places like Valencia and Santa Clarita and big parts of Los Angeles and even Ventura County, some newer developments may have Mello Roos tax. Mello Roos is a special assessment and an extra tax created to fund infrastructure in newer communities. Many sellers don't even realize that they have it because it's buried in their tax bill. But buyers absolutely need to know this upfront. If your home has Mello Roos, you disclose it clearly. You have to identify the amount and identify the district and let the buyer know what they can expect on their property taxes. That is not optional. It is required. Now let's move on to the AVID, which stands for the Agent Visual Inspection Disclosure. This one is not filled out by the seller. It's filled out by your agent. In Los Angeles County, in California in general, agents must walk through the property and make notes about anything they can see with their naked eye. They are not allowed to move furniture or open walls, but they must look for visible defects like stains, cracks, missing fixtures, broken outlets, signs of water damage, and anything else that is noticeable. The AVID protects both you, the buyer, and it shows that the agent took responsibility and documented what was observable. Many sellers do not understand why this exists because it's part of the California's consumer protection laws, and it gives the buyer confidence that nothing was hidden. Now let's talk about the natural hazard disclosures, NHD. Another huge requirements in California. These disclosures tell the buyer if your home is located in a flood zone, fire hazard zone, earthquake fault zone, or high fire severity zone, or any other regulated hazard area. California has strict wildfire maps, and California has strict flood zone maps, and buyers must be informed about risks before they purchase. And this is not a maybe, it's mandatory. Now let's talk about a question I hear from sellers all the time. Rima, what if I do not know the answer to a question? It is simple. You don't guess, you do not assume, and you don't play it safe by picking the option you think it sounds best. You simply check the box that says unknown. You are allowed to not know, but you're not allowed to hide what you do know. Another question sellers often ask is, what if something happened years ago? Do I still to disclose it? And the answer is yes. If it affects value or desirability, you have to disclose it. Here's an example. If your home had a leak like 10 years ago and it was repaired properly, you still disclose the leak and you also disclose that it was repaired and how. You're not just disclosing problems, you're disclosing the truth. Now let's go a little deeper because California law takes this seriously. There are disclosures about death on the property, disclosures about permits, disclosures about additions, and disclosures about work done without permits. And there's disclosures about insurance claims and about previous mold, fire, water issues, and disclosures about anything unusual or unexpected that happened at the property. And yes, even if someone passed away in the home, it must be disclosed even if it was within the last 3 years. California is very clear about this. The most important thing to understand is this. California disclosures are not designed to punish you. They are designed to protect you. Because here's what happens when sellers try to hide things. The buyers moves in, they discover issues, they get angry, and that anger becomes a complaint, and that complaint becomes a letter from an attorney. And now you're dealing with legal action that could have been avoided by simply checking the correct box. So, disclose early, disclose honestly, and disclose clearly, and the buyer has no reason to come after you later. Now let's talk about something that sellers often misunderstand. You are not required to fix everything you disclose. Disclosure is not an admission of guilt or promise to repair. It's simply you telling the truth. If the roof is 25 years old, you disclose it. If the plumbing is original, you have to disclose it. And if the AC does not cool as well as it used to, you disclose it as well. If you had a leak that was repaired, you disclose it. This actually helps you because the buyer now understands the condition up front and cannot claim they were misled later. Let's address the idea of I don't want to scare buyers away. I hear that all the time. And let me tell you something. Buyers are not scared by disclosures. They are scared by secrecy. They're scared by vague answers, and they are scared by missing information. Buyers love clarity, and clarity builds trust, and trust builds stronger offers and stronger closing. When buyers feel like the seller is honest and transparent, they feel safer moving forward. In all my years of real estate, the deals with the clearest disclosures are always the smoothest. Now let me tell you something very critical. Something can save you from lawsuits months or years after your sale. California disclosures are not just paperwork, they are legal shield. If you disclose something and the buyers proceed with the purchase, they cannot later claim they did not know. Your disclosure is your protection. When sellers forget to disclose something, that's when problems happen. Lawsuits don't start because something was broken. They start because something was hidden. At the end of the day, California disclosures come down to one simple principle. Tell the truth, tell it clearly, tell it early, and protect yourself in the process. If you are preparing to sell your home and you want help understanding your disclosures, or you want me to review them with you so you can fill them out correctly, comment disclose below or message me privately. I'll walk you through everything you need to know step by step so you can feel confident and protected. I'm Rima Rafe with the Rafe Group, helping Los Angeles sellers navigate real estate with clarity, honesty, and confidence. So make sure to like, subscribe, and share because every California sellers need to know what to expect with their disclosures.